This is a part heard appeal in the matter of Claimants Limited and another, and Hughes and others.
Ms. Bear, just before we continue with your submissions, I'd like to be clear what there is in hard copy and what there isn't. We've had these two additional bundles a bit waived, but they're a bit historic now. Then yesterday morning, I had in hard copy the note on business connection from Miss Hilliard. That referred to lots of extra materials. Do I have those in hard copy?
That I don't know.
No.
You don't have those in hard copy at the moment, my lord. We are preparing an update to the Radcliffe Chambers bundle you have before you to include those matters. We're actually just waiting for the printing to be delivered. So
Fine,
I hope that we'll make the update to your bundles, your lordships and your ladyship's bundles at lunchtime.
Thank you very much. And then on your side, Ms. Bear, we've had certainly further materials this morning. I forget if there are any more further materials. Not yet in hard copy, but they're coming.
Well, they're being physically assembled as we speak by
Yep. Thank you very much. I'm afraid I'm sufficient of a dinosaur that I do like to have hard copy, and I will have confidence at the end of the case that I have everything if I have it all in hard copy.
Your lordships and my ladyship have been very patient. There's been a significant amount of extra material, and we're all very grateful.
And actually, my lord raises one further point. I think possibly on day one, or maybe day two.
Yeah, not from me.
Found on our benches. So that's from yours.
Did we ever get?
We didn't ultimately refer to it, no. Although the same point is made in our notes, so your lordships and your ladyship will find it within the bundle, which will be updated in hard copy at lunchtime. And for your ladyship, the bundle was provided electronically with just the 3, but we will make a composite bundle so that your ladyship has just the one Radcliffe Chambers bundle, as it were, the same as the hard copies.
And just before you sit down, the version of the bill in this photocopy is obviously different from the final act. But
Yes.
even that says it was amended in committee. Do we have the absolutely original version?
The 1880 version of the bill.
Well, this one, which says Partnership Bill 1880 as amended in committee. So presumably Sir Frederick Pollock's really original version was different even from this.
It was, I believe, it was amended numerous times. There was a bill in 1880, there was amendments, there was a bill in 1889. There was then some further debates, and the Hansard debates are actually in the authorities bundle.
But they probably don't satisfy pepper and heart criteria.
And then there was the act in 1890. I will make inquiries to see if we can find the absolute first version in 1880. I'm not sure. I don't want to give an absolute answer as to whether we have that or not on my feet, but I will make inquiries to find out whether we can get that.
Yep, thank you very much.
If your lordships could turn up the authorities bundle and maybe your last one at tab 94, for anyone using page numbers in the electronic copy, will be page 2310. And this is our extracts from the Law Commission report, in fact, the Law Commission and the Scottish Law Commission report in 2003, under the chairmanship of future Lord Toulson, as I think the Law Commission then was. And one finds on page 2310 an indication that...
Sorry,
it isn't what? 94, page 2310. I do hope that's right, because it's certainly what I've got printed out. Do you have something different, my lady?
Yeah, I mean the PDF numbering is out.
Oh, I'm really sorry about that. I know how frustrating that is. If the other members of the court...
Have it now.
Thank you. Section 321,
Yes.
the 1890 Act being praised as a model, not all comments so kind. The leading Australian textbook comments critically on the results of the long period of gestation of the bill following Sir Frederick Pollock's draft of 1879. So it may not be worth looking at the 11 year. And then one can see with antipody and trenchancy, the bill was resubmitted at frequent intervals, suffering alterations and deletions almost amounting to mutilation, etc., etc. And the court may or may not have some sympathy for footnote 15, where in the second line of work called insolvent partnership describes the act as deceptively clear.
I do have some sympathy with that.
Yes, whether even the adjective as opposed to the adverb is warranted might be a matter of further debate. We're going to look at the. I didn't include that in the authorities bundle for the humour element, but there is a bit we'll come to in due course, which is slightly more personal.
It would be lovely to have the next page
Before or after, my lord?
after, because under the heading missing links, there is some observation about some sections of the 1890 Act. So they're talking about ambiguity concerning the continuance of a partnership where there's a change of
Yes.
partnership. I mean, it's just tantalising. One of the issues that we've been vaguely exploring here, vague in speaking for myself, is the extent to which these sections we're looking at apply both before and after
Yes.
partner exits.
Yes.
And I put that neutrally, dissolution included. But it would be useful just to have the remainder of this section.
Understood. From recollection, I think the Law Commission recommended abolishing the rules about automatic dissolution, e.g. when one partner dies, and obviously that hasn't been adopted. But that's, I think, the general terrain that section is going into, because that was one of the main focuses of the report. Anyway, Myra, we will produce the rest of that section, of course.
I mean, bear in mind, this is just the Law Commission.
Indeed.
And it's not even the Law Commission running up to an amendment to the Act.
No.
But it's nevertheless.
Well, it's
The commentary in a book or something else.
exactly, but it possibly has slightly more value in the sense that there's been not only do you have the structure of the Law Commission, there's been a consultative process that's fed into it, and in this case, it's some extra weight because the consultant to the report was Roderick Banks, who obviously is now the Lindy editor. So anyway, can we come back to the extra materials and what your lordships have there? So we've got a bundle which now should combine some extra materials that were provided by us yesterday morning and extra materials today. So this is a blue 4-stone buildings bundle, and it therefore supersedes the bundle that you were given by us yesterday. Simply, you can discard that.
Do you mean electronically
Yes,
yesterday? Yes,
electronically,
the hard copy.
yes.
So this is the hard
Yes.
copy version.
This is the day 3 one.
Yes, it does, because the day 3 one is now the first tabs of this one. And we've just added some additional things in response to questions from the court and a couple of extra authorities, which I'll come to. So, my Lord Justice Newey, I think it was my Lord, and if not, it was my Lord Justice Snowden asked what proportion of the tests sold by the partnership were to Newfoundland, and unfortunately on the information we have, it's not possible to give you an answer to that question, so I'm afraid we just have to leave it open. Your Lordship asked for extracts from the closings in relation to the Danish deal as a maturing business opportunity, and also in relation to CAP, the Danish outfit, and that we do have, and that is in tab 6 of the hard copy bundle. So you've got the front sheet, and then it is an extract that's been taken from the soft copy. So it starts at the bottom of internal page 94 with a subsection 18, and what you can see, for example, 389.4, you can see set out semi-verbatim, as it were, a contacts list that Mrs. Hughes, whom the judge called LB, circulated with Collinson's sales agents, distributors, and then the various entities mentioned there. It sets out what Mr. Butcher was doing, other customers, etc. And then 389.10 at the foot of internal 96, there is also, of course, the touring opportunity to supply tests for the Danish government. 378 then cites John Taylor's, and 379 shows the way it was put. If the partner takes advantage of a business opportunity which exists at the date of dissolution and which matures prior to the winding up of the partnership, he's obliged to account for this to the partnership. There's no requirement for the business opportunity to be a maturing business opportunity at the date of dissolution.
I'm not sure I understand the difference between the concept of existing business opportunity and maturing business opportunity. Somebody's drawing a distinction that I'm not entirely clear about.
Well, I agree that it's not necessarily a satisfactory distinction, and it was it seemed to be criticised, as we'll see a bit later, in the Recovery Partners and Ragazzi decision in the Supreme Court as being a sort of firm, bright line dichotomy. But the concept, if you look at internal page 108, the citation in the middle of the page from Mrs. Justice Cockrell, as she was at first instance in the Recovery Partners case, says limited guidance as the authorities indicate to me that a business opportunity may be regarded as maturing. So just pausing there, obviously she's saying in principle there is such a thing as an opportunity, and the subset of that being the maturing opportunities. And then she goes on to give an indication, which is limited guidance, of what makes an opportunity one that is a maturing opportunity. Contact's got to progress to the stage where some outlines of future contractual relations are in play. And that was the test that the judge then applied in paragraph 401. And he said, well, as at the date of dissolution, you didn't have any sort of draft contract, as it were, or outlines of a draft contract.
I mean, there's a flavour here, isn't there, of in what Mrs. Justice Cockrell went on to say, as quoted at 388. It has to be at least something which you could at least in equity identify as something which is to be treated as if it were property of the company. That made, I think, on day one, that even when you're interpreting the word property in section 29, you probably need to bring in some sort of equitable principles, because otherwise, if you just took a literal common law approach to the meaning of property of the partnership, you would exclude that which equity would regard as property. But the key is perhaps that at least it has to be something.
It's a
that you could sort of at least ascribe some sense of property to, or however loosely you define that.
it's
As
rather
to
like,
just being some sort of idea.
wasn't it Lord Macnaghten who said in the Muller's case that it's easy to describe and very difficult to define, or words, and there is, as with confidential information, where a similar debate has occurred and is ongoing, there's a question of, is it sufficiently specific? So to allow you, I suppose, a philosopher would say ontologically, to at least identify the thing. If you can do that, then describing it as property has a...
That may feed into the debate we were having yesterday about whether taking those three words together, or the section 29 together, and then putting it in the context of what went before in the case that you showed us the name of, which I can't remember, from 1840.
Willett Blanford, is it? Yes.
You know, that this is something to do with the idea that you can't, without paying out a partner, or without essentially conducting some sort of sale of the partnership assets, business, continue to use some property of the partnership as its own.
That's the as it were notional sale is, I would respectfully suggest a stage further, but and I would also suggest that when you look at business connection and just taking the, I suggest, indisputable case of somebody who's a repeat customer but doesn't have any contractual relationship, just the regular user of the business, what is the thing there?
Yeah, but goodwill, that is the attractive force that brings customers in, is described in some sense as goodwill, which has been sort of recognised as having that.
Indeed, but I mean, it's all you're looking at in the case of the customers is, or rather, perhaps not all. Let me rephrase that. It's sufficient to say that there are people, customers, who have a propensity of dealing, and so you've got to look at business connection in that light. And I would suggest, so far from being a sort of further species of property or analogous to property, even in the broad sense which my lord is talking about, which I respectfully adopt. In fact, what business connection does is expand the concepts of what I use, again trying to grapple for a neutral word, the resources of the partnership or the advantages of the partnership that it has, and it is attempting, in my submission, the section is attempting to arrive at a, we would now say, if we use the jargon, holistic approach, a global approach to what are the aspects of the partnership's business which are commercially valuable.
Just picking up another point, and I'm not sure this matters for our case actually, but you say, well, it doesn't matter when you're trying to look for maturing business opportunities, whether it's pre or post dissolution. I think you were saying that a moment ago. I wonder whether Section 38 does bear on that, because Section 38 says rights and obligations continue so far as necessary to wind up. So the partnership doesn't have any continuing interest in new business. It's winding up.
Well,
so I'm not sure if something comes along post dissolution when the partnership is winding up, I'm not sure that could be relevant.
The obviously that's not this case, but I'll show you authorities which say that the.
Well, sorry, you say it's not this case. That rather depends on the view you take of the facts, because the judge certainly in places did say that the Danish deal was not sufficiently realistic. It was not realistic to call the Danish deal an opportunity at the date of dissolution.
He said it was an opportunity. He said applying the sort of test that Mrs. Justice Cockrell applied, it wasn't a maturing business opportunity. So, but he did find at 404 that it was an opportunity. And he also found in 403, 401 level 6.
He said, I do not consider that it is realistic to speak of an opportunity to pursue the Danish deal as at the date of the partnership's dissolution. So I think that's wider than saying it wasn't maturing.
That is, if I'm remembering correctly, where he also says in the form in which it was ultimately transacted.
No, it's not.
Let me just check though.
He said in the form ultimately transacted was at 4016,
yeah.
But then 403 he restates it as I've explained. I don't consider it's realistic to speak of an opportunity to pursue the Danish deal as at the date of the partnership's dissolution. I'm not sure quite where because that doesn't include the words in the form ultimately transacted in his formulation. I mean, we're going to have to sort of figure out what he was actually meant in between 4016 and 403. You stress 4016 and say, yes, but look what he underlined, but in 403 he doesn't.
Yeah, but in 404, which I mentioned a moment ago, 2 lines up in the end, it was an opportunity that the partnership was entitled to pursue. So I was showing you what the way it was put in the
Yes.
claimant's closing submissions,
Yeah, okay.
where it was said it doesn't need to be paragraph 379. If you take advantage of a business opportunity which exists at the date of dissolution, you're obliged to account for that. Obviously, there are a number of separate channels to that, all of which are, in my respectful submission.
So 379 accepts that it must be an opportunity that exists at the date of dissolution, not a maturing business opportunity. Is that right?
Yes, that's the argument that's being made, that which although it's not exhaustive of liability under section 29, in my respectful submission, was a correct argument, and also in my submission is reflected in the, if you look at what the judge says as a whole, in between paragraphs 401 and 404, applying the well-known canons that you mustn't excessively focus on each bit of individual language of the judgment, etc. So we, as in my clients, did draw a distinction between an opportunity existing at the date of dissolution, which, following what my Lord Justice Snowden has indicated, could then, in appropriate circumstances, be considered as property if it had the necessary degree of specificity, things you could point to and identify about it. And we say, well, the presence of the ACON test in the Danish study through a registration made by CAP, which was a business contact of the partnership and under contract to the partnership, gave the opportunity that degree of specificity and gave the situation, if you like, that degree of specificity, etc.
But what the judge, I mean, the one explanation for why the judge's language in these paragraphs may not always be consistent or clear in this respect is that he has said much earlier in the judgment, I can't remember exactly where, that it's wrong to look at it in terms of business opportunity, maturing business opportunity, because he says that's not what's said in this statute, section 29, and he just takes a different approach to the word business connection. So he severs, so that's why he's not, I suspect, quite as exercised by the precise maturity which the opportunity has reached at the point of dissolution, as might have been the case.
Yes, it wasn't
approaching it on an equitable basis,
and also because the fact, as he had found in paragraph 394 or 395, whichever it is, that at least part of the reason was for getting the Danish deal was the ACON relationship, which was a business connection. So that meant that even if you hadn't had the specificity of the Danish opportunity, if Mr. Hughes was deriving a benefit from using the ACON business connection, which was a business connection partnership, then that on its own gives you invokes section 29. The reference for my Lord's note is paragraphs 244 to 245 at page 133, where the judge reached the conclusion about section 29, essentially saying you apply the language of this statute. Just moving on, if I can, just to show you, because we were asked how it was put. Paragraph 389 makes the point that there's a difference between directors and partners in the sense that the maturing business opportunity, which I think stemmed from the Canero case in the Canadian Supreme Court, is a company director test, and when a director leaves.
Sorry, which paragraph are you on?
389, but on internal page 108 of tab 6 of this bundle.
Oh, I'm sorry. Sorry, I thought you were back.
So sorry. Yes.
Sorry, I thought you were in the judgment. Sorry.
Forgive me.
389.
If I understand these closing submissions, they're based on an interpretation of what Lady Justice Arden said in John Taylor's at 34, which is cited at paragraph 378, where she referred to the maturation of some business opportunity in existence at the date of dissolution. As I understand it, you're reading that as meaning as long as the opportunity existed at the date of dissolution, even if it was not then maturing, then that is sufficient. That is not the only interpretation of what.
No, I didn't
Justice
write these
Arden
submissions.
I'm trying to understand. I was trying to understand where 379 comes from, and I think it's that. And I'm just.
Well, it's not only that. So I fully agree with my lady that the Lady Justice Arden, if you just look at that language, it's indifferent as to whether the business opportunity was, quote, maturing at the relevant date, or
the facts of John Taylor's was.
well, one could say so. In the sense that there had been discussions that had started in October of 1998, and the dissolution was at the end of the year. So that's true, but that's not the only the textual exegesis of John Taylor's is not the only reason that there is or that was put forward in these submissions. Without wanting to dwell too long on them, because you've now got the benefit of it, is a benefit of my argument, and it's for you to decide what the principles are and why. But 389 just made the point that there's a difference, which I suggest must be the case, between directors and partners, in the sense that when the director leaves the company, then the fiduciary relationship comes to an end. Not that the fiduciary duties don't come to an end, that's what the recovery partners case says, but the relationship does, whereas when a partnership is dissolved, the fiduciary relationship does not end, and that's a critical difference, which is very easy to overlook because we automatically slip into thinking of dissolution as a termination, but it's not. It introduces this so-called twilight period, a somewhat grey area, I accept. There is authority that I will take you to say that the duties, saying in terms, the duties continue.
Right.
And section 29, in terms of the law of the case, it is important that we bear this in mind. If I could ask you to go to the judgment.
Are you leaving these submissions?
No, so I'll come back to my point on the judgment. I'm just going to show you, if you go forward to the next set of pages, which start at internal page 1, 2, 3. So that just give you extracts, and you can see the first full paragraph number is 455. That then deals with CAP, because my Lord Justice Newey also asked about.
You say deals with CAP. That doesn't identify CAP as a connection, does it?
The judge found, or sorry, he expressly said that CAP might or might not be a connection.
No, I followed that, but just looking in terms of what you were arguing, I mean, to some extent, what this reveals is that the way the judge ultimately approached things wasn't necessarily quite how the parties had put it before him, perhaps. Now, I do see back at 380, on page 106, a specific reference to ACON as a connection.
Yes.
As you say, there's then a lot of stuff about CAP and the development of the Danish deal. Is it anywhere said that CAP was a connection?
I haven't seen. Well, yes, sorry, it is. Forgive me. 457.
457.
457. It is said Hughes healthcare in relationship with CAP also
Yes,
a business connection.
Yeah.
So, and as we'll see when we look at the not perhaps crystalline clarity of the procedural directions that have been made, but there were a list of issues for trial 1. So there was an order, and it's in the materials that you have, I think. Yes, if you go to, staying in this hard copy bundle, if you go to tab 9, you'll see that there was an order that set up a trial 1 and trial 2. That's page 2, paragraphs 3 and paragraph 4 of the of the case management order in April 2023, just saying that there shall be a first trial and a second trial, and then at the bottom of the page, list of issues. Parties shall endeavour to agree a list of issues for the first trial, and then that then matured into the second order, paragraph 24, page 4 of that document. That order was made in August 2023. Paragraph 24 says that the list of issues first trial should be those identified in the list of issues. We've got that in this page, in the list of issues.
You've certainly been given it.
We've been handed
Yes,
that.
you've been given it. So
Let me just,
if you have that to hand, you'll see, I'm sorry to ask you to jot around, you'll see that paragraph 33 of the list of issues. Paragraph 33 of the, I only need a hard copy of it. Paragraph 33 says that the court is, an issue for the court to answer is there a need to, or what are the circumstances in which you have to account? So I'm going from memory because, okay, right.
the life very findings, what categories of assets, business opportunities and or business need to be accounted for.
Yes, exactly.
by
So,
Mr. Hughes.
Sorry, do you not have a copy?
Do you want one?
And the only reason I asked that is because
no, I've had a copy. I just,
it's quite
Not
interesting,
one.
isn't it? The way paragraph 32 4 is phrased.
well, I mean, 32.4 and 26.2 framed in similar terms.
Yeah,
So, but the
the parties were using the expression connections
yes,
as a
well, it's a list of issues.
Yeah.
Whether we should, as it were, take the plural as including the.
no, but it rather sort of perhaps shapes some of the thinking. Perhaps might be said to have shaped a little bit of the thinking that the judge had about the meaning of business connection, ex singular.
I mean, he doesn't refer to it, my lord. The paragraph 33, which is the I suggest does have a link to the eventual order, is the sort of mission for the court in the light of any findings concerning the above. What categories of assets, business opportunities and or business of any need to be accounted for by the defendants, and the form of paragraph 1 of the order sets out then what are the categories of assets, business opportunities or business which need to be accounted for, including the Danish deal and the subsequent sales to Waitrose and the like. So that's the target for the judge, and it's also the target, thank you, that my own friends have to say the judge wasn't entitled to reach if they want to set aside the order, which is the basis, of course, on which the notice of appeal is put forward. So that's CAP, and the only other just before we turn back to law, where we broke off yesterday, one just notes that in this bundle, backing up, as it were, what the judge found in the sections that we went through yesterday, paragraphs 387, 388 of the judgment and so on. If you look at page 124, for example, section 400, for paragraph 456.4.
In the submissions.
In the submissions, thank
Sorry,
you, my
yes.
lord. 456.4, subparagraph 2. That Mr. Hughes sent Mr. Butcher, who forwarded to CAP, validation and test results for the ACON test.
Sorry, lost.
I'm sorry, my lady, so-
Claimants written submissions again.
Yes, claimants written submissions, internal page 124 at the bottom,
Thank you.
subparagraph 2 in the middle of the page. So information being provided by the partnership. And then 456.9 on the next page, Mr. Hughes sends Aecon a list of Hughes Healthcare's prospective clients, including the Danish government, asking that if any of them made contact directly with Aecon, to refer them back to Hughes Healthcare. So in terms of specificity, if you like, I'm not saying this, whether or not focusing on whether or not this makes it property, but just in terms of specificity, you've got the Danish government identified as a prospective client. And then if you go forward to, we looked again at the ultimate answer to that. So page 127, the argument in subparagraph 2 of paragraph 456.17, MSDL, Mr. Hughes Company, would not have been selected to supply tests to the Danish government had Hughes Healthcare and Aecon not successfully participated through CAP in the university hospital study. And Mr. Butcher in subparagraph C accepted in his cross-examination that the plan from February 2021 was to get the product validated with good results in the hospital program in Denmark, would create a good opportunity to get business from the Danish government. He accepted that if the partnership had still been in existence, the deal would have gone through the partnership. So, and then the conclusions drawn at the internal page 130 that we looked at, and we didn't look at paragraph 458. It's itself that you can also see in the middle of that paragraph. It was an opportunity existing prior to the dissolution of the partnership, which Mr. Hughes exploited for his benefit. So that's submission 1. Submission 2, which I accept the judge applying the test that he did rejected, was that it was also a maturing business opportunity at the date of dissolution. The judge disagreed with that, but in any event, as they point out, it has matured during the period of the operation of the obligation under Section 29. Again, that comes back to the difference between directors and fiduciaries who are partners.
The risk, if this takes us into a long digression, we better not pursue it because I don't want to interrupt you for too long. But you point out in 457, there's a reference to a business connection, CAP being a business connection. Now, the judge in the end makes no finding about that.
He says
it's
not
possible.
Yes.
We've seen from the list of issues to be determined at the trial that those were to include findings about what categories of assets needed to be accounted for. And on the case you were outlining yesterday in this respect, you say, because of the connection with CAP, Mr. Hughes had to account. That was one limb of your case, as I understand it.
Yes.
And the judge hasn't determined that.
The judge didn't say that, didn't determine that CAP was a business connection.
And therefore, he did not make any finding as to whether or not Mr. Hughes needed to account because CAP was a business connection. He leaves the question open in a sense. What's the implication of that?
The implication is that it's still open to be found in trial 2, just in purely practical terms, that's something which may trigger or be a further trigger, as the case may be, an obligation to account under that part of the judge's order.
But that seems to be something that's intended to be dealt with in trial 1, whether or not this is a category of asset that needs to be accounted for.
That's if you, I mean, that's not how I read the order. It's certainly not how, with respect, I see the judge as having determined the issues. The judge, in effect, said, I answer issue number 33 by saying, here are the categories of asset or business for which an account must be made, but the basis on which that account is taken hasn't been comprehensively defined by the judgment. So some aspects remain still to be answered in the light of the judgment.
It does seem a problem because suppose the judge were wrong about everything else. Well, you say, well, I've still got my claim that CAP is a business connection, and that means Mr. Hughes has to account. And therefore, on that basis, one leaves for the second trial, you know, a question that is absolutely fundamental to this litigation and was fundamental to trial one.
Well, obviously that's not my primary position.
No.
I'd say that the judge's reasons got there, but I mean, if the position is that the judge gives a number of reasons and the Aecon business connection was one, I do say also that the judge's findings that I took you through yesterday would amount to already do amount rather to a basis for the account being taken under section 29. But yes, you've then got this issue that the judge left open about whether CAP and Mr. Butcher were business connections, and I agree that in isolation, of course the judge didn't determine in isolation, that would leave you with a slightly messy result. But nonetheless, if that is the conclusion of what's happened at the end of a complex trial, then that is where we've got to. And there isn't an appeal on a sort of procedural basis that the case management structure that might emerge was inappropriate or in some way an error.
I was putting to you, I'm sorry, I may just be giving you a bit, and he'll correct me if I am. Issue 26.2. Has Mr. Hughes used the name and or business connections of the partnership other than for the benefit of the partnership and its business post dissolution of the partnership? If so, how? I think the point that's being put to you is the judge was expected to determine the how at trial one, and it would not be left to be determined at trial two. And if you haven't got a determination that CAP is part of the how at trial one, it's not open to you at trial two to say part of the how is CAP. I mean, I may be wrong about that question, but that's certainly the question that appears in my head.
I think you say the order leaves it open
Yes,
for that to be determined in trial two, even though on ordinary principles you'd think that would be someone trying to re-argue their case potentially on a different basis.
well, it's not re-argued on a different basis. At paragraph 285, I'm reminded by Mr. Crossley, the judge expressly says this is a matter for trial two.
Which would be sort of fine if it were an incidental matter in the quantification of the claim. But, I mean, I know you have all sorts of other arguments, but this could be the sole basis for the claim, and yet that's left to trial two.
Yes, well, I acknowledge that if one got to that point, that would not be an optimal situation, nor is it my primary case. I don't give anyone the impression that we would say that's the ideal outcome, or that is the outcome, more to the point. But nonetheless, if that's where you end up, where the court faced with the trial judge, I mean, just looking at it from another angle, trial judge faced with an enormous raft of issues. He writes a 100-page judgment, comes to conclusions on a great number of issues, doesn't come to conclusions on others. If hypothetically the situation were that some of the conclusions he's reached are impugned, does it follow that then the claimant gets nothing, even though the judge has expressly said, well, this is a matter for trial two? In that case, I do suggest that my clients would have a sense of grievance if they're then told by this court, well, sorry, even though the judge left this point open, you get nothing under the partnership claim. Obviously, I know there are contract claims which are separate altogether. We haven't discussed those. Can I? I'm slightly conscious of time, and I don't want to be accused of evading any questions, but
no, you haven't been evading the questions. So
be doing
take your
impression of
course.
Peter Sullivan come this afternoon. So My Lord Justice Snowden posed the question yesterday afternoon, what would there have been to sell in relation to the Hughes healthcare? And more than I summoned to mind at 4 p.m. would be one answer. I'm just quickly going to try and answer that now. The first thing to sell would be the right to trade under the name Hughes Healthcare. The judge specifically held that no license from HGL, Mr. Hughes' company, was required, and specifically held that the right to use the name was, quote unquote, an asset of the partnership, pages 95 to 96, paragraphs 49 to 52. Hughes Group Limited was held by the judge at paragraph 48 to be buying from Acon as agent for the partnership and holding monies received from purchasers as a nominee for the partnership. In addition to the name, the judge also held that the partnership had branding in the sense of a distinctive logo and quote unquote, and the ability to generate sales over a website. That's page 171, paragraph 420, little 4 and little 5. The goodwill in the Hughes Healthcare name, the judge specifically held was quote unquote owned by and an asset of the partnership. Not only paragraph 52, which I just referred to, but also paragraph 427 on page 173, subparagraph 1. He rejected the contention that the Hughes Healthcare goodwill was valueless or negligible. He rejected that at pages 130 to 131, paragraphs 236 to 238, and also at paragraph 427 that I just mentioned. He held that the goodwill was an asset of the partnership because successful trading, in his phrase, caused some goodwill to attach to the name. He also held at page 173, paragraph 47, little 2, that there was goodwill, which he described as property, using that noun, consisting of having a functioning and viable business capable of sales, capable of generating sales. And that property, he said, included goodwill arising from trading operations, customer relationships, the ability to generate sales. That's 427, little 2 and little 3. It also included confidential information with the details and the history of customers and their deals, 427, little 2b. I don't think I took you yesterday to 125, that's page 125, which I would like you to look at, please. Page 125. Under the subheading going through the emails on 25-26 June, para 207 on the 25th of June, Mr. Hughes accessed the HGL email accounts of Philip and Freddie Manduka. He used his administrator access and the fact that they hadn't changed the passwords on their email accounts. He read a large number of their emails, 208. He forwarded some 95 of those emails that he read to Ms. Blythe or Mr. Butcher or both. 209, no real pattern, but some were details of leads that AA or Anita Shui had passed to Mr. Manduka or his son. And he gives an example of contact details from the SMI group. Is it worth a call, etc.? 210, there's then further reference to leads. 211, the salient feature, says the judge, of many of the emails forwarded is that they contain the names of people who could be presumed to be interested in purchasing LFTs. They were actually purchasing from Newfoundland, contained the names of leads that Acon had forwarded. So this is the important fact that Acon sends back to the partnership details of people who've contacted Acon, because Acon doesn't want to deal with them. It wants to channel itself through a very select group. And Mr. Butcher accepted the unifying theme details of people purchasing, and 213, Mr. Butcher sent an email just the day before the dissolution notice. He was literally counting the hours into Monday so we can begin to bury them. So Mr. Hughes, for his own personal competitive purposes, within what the judge went on to find was the plan that Mr. Hughes had formed from about the 15th of June to take all the business for himself, to exclude Mr. Manduka, not to account for the benefit of that business. That's obviously another wrong that Mr. Hughes was committing. Coming back to the assets and the property and the resources and the things of the partnership, sales materials were referred to at a number of points in the judgment. They were referred to, for example, in the genesis of the Danish deal, because sales materials were provided to an CAP, which persuaded CAP, as the judge specifically finds, to enter Acon's test into the Danish university's study. Those materials are referred to by the judge at page 171, paragraph 420, little 3.
420
sub 3. Customer relationships are treated as business assets. The judge, I've already referred you to paragraphs 236 to 238 at pages 130 to 131, where the judge held that Collinson's wasn't the only customer. He expressly rejected Mr. Hughes's repeated evidence on that. He also held at page 172, paragraph 422, that customers are not limited to those who transact on any particular date. And we looked this morning at the customer list and contact list on the 15th of June that was forwarded and passed between Mr. Hughes and Ms. Blythe. The partnership also had a sales force, which the judge deals with at page 102 and onwards, under the heading the sales force. Perhaps we can quickly look at that. Starting at the top of page 102. He says at the end of paragraph 79, it's appropriate to start by making factual findings as to the individuals who comprise the partnership's sales team. And then after mentioning Mr. Freddie Manduka and Mr. Hodnett, he says, 81, Mr. Butcher worked in the partnership's business from January 21. He was a friend of Mr. Hughes, who thought he had an impressive book of contacts. He was well connected. Middle of the paragraph, on the 18th of January 21, he signs a mutual confidentiality agreement. And the judge finds at the end that became a binding contract between Mr. Butcher and the partnership. And then 83, a revised version is signed by Mr. Hughes of that, and the judge infers that that became a binding agreement between the partnership and Mr. Butcher, and by clause 11, the partnership gave Mr. Butcher exclusivity in relation to, among others, large corporates such as Unifar and Bunzel, and also the Danish government and the Namibian government. So the Danish government is specifically identified as a prospect of the partnership, and it is allocated to Mr. Butcher as the contractor.
Sorry, I just lost the thread. This was a list of assets.
Yes, well,
I got customer relationships. Is this under the heading of customer? What's the heading of asset here?
The heading of assets. Well, I'm running it a little bit together, but it's the partnership sales force, which comes under the broadly under the heading of the judge's finding that there was goodwill consisting in the ability to generate sales and what he called a functioning and viable business, which he refers to at paragraph 427.
What would a purchaser, in relation to Mr. Butcher, what does a purchaser get?
Well, he could buy the benefit of the contract, couldn't he, with Mr. Butcher?
What, the confidentiality?
Well, yes, and the exclusivity that's been given to Mr. Butcher. So there's a mutual confidentiality agreement.
Hang on, so sorry, which contract is so we get to the point that dissolutions happened. The partners, on this hypothesis, set about immediately winding up the partnership's affairs. So they say we better sell the assets. So in relation to Mr. Butcher, what do they sell?
In relation to Mr. Butcher, they sell a mutual confidentiality agreement, and Mr. Butcher being given a license on the partnership's behalf to pursue these prospects. So the prospects are
But
identified.
they can't sell the license given to Mr. Butcher.
But sorry, the opportunity is by this very nature of the agreement identified as an opportunity of the partnership, and so they're
not selling the opportunity either. I mean, sorry, they're selling their rights under the agreement such as they are signed between Mr. Butcher and the partnership. I understand that, but we
yes.
haven't been asked to look at that agreement. At the moment, it seems to be a confidentiality agreement.
They've got an agreement which defines as confidential to them information, including which would necessarily include the prospects, and so those prospects generated in the course of their business are being sold, and they've got a what the judge called a functioning business, including Mr. Butcher, part of the sales force, who's capable of exploiting that and has been tied in by this agreement.
But and I don't know how far it matters, but suppose you do want to realise the assets of the partnership at once because you've had a dissolution. So you want to sell something to a purchaser. The purchaser gets the name. You say he gets the benefit of this confidentiality agreement. So there's an assignment by the partnership to the purchaser of the benefit of the confidentiality agreement.
Yes, he's. I mean, I'm starting at page 173 is the basis of this, where the judge concludes non-exhaustively that the following matters are embraced within the concept of the partnership's property, name, and business connections.
But at this stage, we're not. I think what my lord was asking about was not necessarily what all that means, but what you can sell to a purchaser on dissolution.
Yes, well, I submit that you could sell the benefit, whatever precisely it was, of the contract with Mr. Butcher and of information that contract dealt with and of the sales prospect, which was part of that arrangement. So the
The mere fact you mentioned a sales prospect in an agreement with Mr. Butcher and say, dear Mr. Butcher, you must promise to keep that prospect confidential, doesn't entitle you to sell the prospect. I mean, you sell his promise to keep it confidential, but you don't sell the prospect.
You maybe have an expectation that he will make use of the benefit of the exclusivity to exploit the opportunity, but the judge doesn't find that there's, for example, any obligation on Mr. Butcher to do so.
And he may only, in fact, he was an employee.
no, but it's
There are no employees. Is it right? There are no employees of this partnership.
they're all engaged under contracts that they were not employment contracts, payment by results, I think. But I do, with great respect, suggest that in a I mean, it's not the test, but in a commercial sense, when you look at this through the lens that the judge did, that as he finds in an unchallenged finding, there was a functioning, viable business capable of generating sales. This is part of what underlies that. Would a purchaser be prepared to pay for this network of arrangements and information in the context of all of the other aspects of the business? And I submit a purchaser would be prepared to pay for
The trouble
that.
is, what do they get? They get the right to use the name. They get seemingly the benefit of a confidentiality agreement under which Mr. Butcher says he'll keep certain things confidential. What else do they get?
So they get all of the. I mean, there's a whole series of arrangements which the judge then goes on to find, where he talks about the sales force.
But does the purchaser get the benefit of any contract with any of those people?
Well, why would he not? We're talking about a hypothetical sale. I understood your lordships were asking me what if you wanted to sell the business, how could you do it? And I'm drawing your attention.
So individual X is employed by Mr. Manduka and Mr. Hughes. Mr. Manduka and Mr. Hughes wish to sell something to a purchaser. So the individual X is then employed by the purchaser. No, there isn't an employment contract.
No. Can I look at just look at paragraph 86, which I was about to. Mr. Butcher also entered into an NCA on 21st of February 2021. I have no idea what that stands for.
Non-compete, I suspect.
Well, I don't know. It could easily do, but.
Well, I'd be very surprised if it didn't, because if you look at the second sentence, it says
Yes.
by the NCA he agreed he would not deal with,
Yes.
otherwise become involved with. That's almost certainly a non-compete.
I suspect that's right, my lord. I just didn't want to guess.
Do we actually? That's fine. Okay, I can speculate. Do we actually have anywhere in the bundle, just out of interest, the mutual confidentiality agreement, or indeed the NCA?
Not that I seeing we've got the judge's summary of it. So just tell me what it says.
MCA is it?
What does it mean?
So the MCA stands for non-circumvention agreement.
Oh, right. Okay.
That's why I hesitated.
You were absolutely right, and I apologise
I wasn't asking an
for diving
apology.
in with both feet.
And the mutual confidentiality agreement is in the Respondents unagreed bundle at tab 7, page 38.
Is that the June one?
It's the June one, yes.
Yes, so that is a different later one which Mr. Hughes himself signed, not on behalf of the partnership. There is a document with Mr. Butcher, but I was being asked what would you sell. So the non-circumvention agreement, but I respectfully agree that it comes to a non-compete agreement, the NCA. And Mr. Butcher agreed that he wouldn't deal with or otherwise become involved with any entity introduced directly or indirectly by the partnership. So it precluded him from seeking to purchase tests from Acorn. So
Just going back to the mutual confidentiality agreement of the 15th of June between Hughes Healthcare, a division of Hughes Group Limited, which I suspect is thought to be synonymous with the partnership. Isn't this the one the judge said effectively was treated as something similar to the one on the 15th of March?
no, that's one in January. And the March one is the same. Those are all what you might call legitimate agreements. The 15th of June one is part of Mr. Hughes's conspiracy, where he's now setting off on his own, privately signing up Mr. Butcher.
So we don't know whether it's in the same form as the ones earlier.
We don't know that from this, and in my submission, it doesn't matter. What does matter is that there is in my submission, a network of agreements whereby, at least indirectly, an identified prospect, in this case the Danish government, it has the opportunity secured for commercial protection, valuable commercial protection in the form of legal rights is secured. There's a contract with Mr. Butcher, there's a contract with CAP. And what that means is that the partnership does have legal rights focused on that opportunity, that prospect, which has been identified of the Danish government, and it has the vital practical step that's been secured of the test, which it is in a position exclusively to exploit, the Acorn test, through Mr. Butcher, through CAP, being registered on the study, waiting to perform well, waiting for the virus to pick up, waiting for the opportunity to materialise. I was simply going to finish off. There are other members of the sales team that are then mentioned in paragraph 87. So the Mr. Butcher who signed this non-circumvention agreement might, but for the agreements that he's entered into, confidentiality and non-circumvention, might very well be in a better position than the world at large to solicit ACON and persuade ACON to let him into the club of those with whom ACON was willing to deal, which was a very small club at that stage, consisting of only one for general sales in the UK, which was the partnership, and Medco, which had been permitted to tender for what it eventually won, which was the DHSC contract, just the DHC channel. The partnership wanted to keep it that way, and hence Mr. Butcher was required to enter into these agreements, which ensured that he couldn't appropriate for himself the benefit of what I submit, the judge correctly found, was the business connection of the partnership with ACON, and these agreements reflect that. The business relationship, as I've said, was selective, to use the judge's word. There's no need to take a binary approach, that it's either exclusive or nothing. Restrictive is also enough. And so if you are one of a small club of distributors maintained purposely by a supplier, who, unlike the Times or Nestle, to use examples that have come up, will actively turn away new business that approaches it and channel it back to you, as the judge repeatedly found, then that supplier is part of your connection. And the being in the club, or being on the panel, if you like, is a very valuable opportunity and a very valuable asset. Very valuable arrangement, the number of nouns that one could try and find. So that's by way of a better answer than I managed on my feet yesterday in response to, or I hope a better answer, a very longer answer that I hope we can agree on, to the question, what might you be able to sell? Ultimately, that is a sort of thought experiment, if you like, to help one consider to what extent there might be a business connection. I don't think anyone would suggest, well, I say I don't think anyone would suggest, I think there is a suggestion that in fact it may be part of the test, but I would refute that, rebut that.
Well, it was prompted primarily, I think, by the 1840s case that you took us to, and sort of the showing us, in a sense, what the 1890 Act followed.
Yes, I mean,
logically replaced, followed, supplemented, did say what you will about it.
Yes. The Willett and Blandford doesn't suggest that unless something can be regarded as a saleable asset, you can't have an account. It's put on a much broader basis than that, in my submission. The key point is it shows that you look at all the circumstances of the business. I was going to come to section 46 of the Partnership Act, because I started on that just before the break yesterday, and I think I mentioned the case of M. Young against Zahid, which is a case of this court, judgment of Lord Justice Wilson. And you'll find that at tab 38, and I'm sorry, I don't know which bundle it is, in electronic page 681. So the question is, I think you may have been told about this by Ms. Hilliard, either in writing or in orally, but the question was whether a Mr. Lees had become a partner in a firm, and whether the definition in section 1 of the Partnership Act was satisfied. He, Lees, was an experienced solicitor who joined a couple of others much younger, so that a firm could be set up he didn't get a share of the profits, he just had a fixed fee. And the question was whether that meant he wasn't a partner. The primary proposition at the bottom of page 681 of the bundle, page 2565 of the report, paragraph 7 at the bottom of the page, primary position on behalf of Mr. Lees is that unless he's entitled to participate in the profits of the firm, the person cannot in law be a partner of it. And that was said to reflect previous law. The definition of partner, you can see at paragraph 9, it's a relationship that subsists between persons carrying on a business in common with a view of profit. So, the risk of a slight oversimplification, that doesn't require actually sharing the profit, it just requires carrying on the business and the business having a view of making a profit. And the question therefore was, part of the question was whether previous law mattered or paragraph 32 is on page 690 of the bundle. Contains the critical reasoning that Lord Justice Wilson agreed, third line, that an agreement for a person to be paid a specified sum for work to be done by him on behalf of a firm does not preclude his thereby becoming a partner of it. No authority for the contrary proposition will be derived from the 1890 Act, even though it would have been simple to provide for it, either in the core definition in section 1.1 or in section 2.3, which addresses receipt of a share of profits. Dropping down, on the contrary, the words of the core definition are wide enough to render recipient of payments in a fixed sum of partner, provided that there is a business, that it is carried on with a view to profit, that's the business, and crucially for present purposes, that is carried on in common with another or others. And in this sentence, indeed, in that a definition is a precise statement of a thing's essential nature, I would regard it as inconsistent with section 1.1 and so not permitted by section 46 to graft onto its words the previous requirement at common law for participation in profits. So in other words, at some point, there will come a point at which what Lord Justice Wilson called a graft is not going to be permitted, however clear it was in the previous common law or judge-made law, because it intrudes too directly onto what the statute provides. And we say, if one tries to put in additional requirements, such as an independent breach, fiduciary, etc., my lords and my lady, I'm sure have the point, then that's just the sort of exercise which you can see from the M. Young case doesn't fall within the inclusionary limb of section 46. On the contrary, it is part of what section 46 excludes because it is, quote unquote, inconsistent with the way in which the Act itself is framed. And so we say, well, the wording of section 29, creating a mandatory duty to account on the occurrence of specified conditions, is sufficient and should be looked at on its own, and to put anything else into it by way of additional conditions would be inconsistent. And so the starting point for much of Ms. Hillier's argument, which is that there has to be some independent breach of fiduciary duty, can't be right, because it's not what the statute says, nor, looking at it a different way, is it right to say that you should read in additional qualifications of another kind, e.g. as to what must be meant for something to qualify as business connection. Can I now turn to that topic, which is obviously front and central as the argument has evolved? I think we saw, and I don't need to take you to it, that same phrase business connection was used by Lord Justice Lindley in the R's case, whether or not with the Act subconsciously in mind. We say, as I indicated yesterday, that what it means is the totality of a firm's business relationships or commercial relationships, and it's looking at relationships which are valuable, of commercial value to the firm, hence there being a business connection. We say that there is no general rule, and the court, with great respect, should resist the temptation to try and propound some judge-made definition on top of these ordinary English words, even though they are now, nearly a century and a half later, a little bit old-fashioned, but nonetheless ordinary English words, any more than it was possible for, from a different perspective, of course, for Vice-Chancellor Wigram to formulate a general rule in Willett and Romford, which he declined to do. We, of course, can accept that as a matter not of definition, but of likely application, a purely transitory relationship may not count. But it's all going to depend on the circumstances. So a newsagent selling items for a few pounds to people who walk in and out of a shop isn't necessarily a sound analogy, and the sort of verbal formulations one would use to describe that business's arrangements isn't necessarily a sound basis on which to analyse and evaluate a completely different business, and this one operating as it did in the almost unprecedented circumstances of the pandemic, and what the pandemic had generated, which was a massive national and indeed global need for testing, which the partners had accurately anticipated back in September 2020, and had managed to get themselves into a favourable position to meet by sourcing, as I showed you yesterday, through the Chinese factory agents of the partnership, sourcing a supplier, Aecon, who turned out to be a good quality supplier, and then assisting Aecon to get the vital step of UK government approval, etc. So here in this situation where it is perhaps one of the great sellers markets of all time, with everybody in the world exposed to a disease and a need to find out if they have it, and a certain number of suppliers who can give the device that enables you to see whether you have it, whether you have the disease or not. A commercial relationship from which one of the partners may derive benefit, in the words of Section 29, derive benefit, so that it is then appropriate for that partner to account to the firm, which is what Section 29 requires, may, in my submission, involve potentially a great variety of features, but non-exhaustively and simply as examples of possible indicators or indicia. One might look at the magnitude or importance of the commercial relationship to the firm. You would look at the persistence, or what you might call the repetition in fact, of transactions within the relationship. What's sometimes referred to and has been in customer cases for many years as habit of dealing. You might look at structural factors which could incline both parties to continue dealing with each other. So on the part of the partnership, obviously, the factors I've just mentioned about Aecon's quality and the massive market demand, and on the part of Aecon, what the judge says was it's found as a fact, not challenged, was its business model, paragraph 127. So for whatever reason, although the judge thought it was absolutely logical, Aecon wanted to have what I'm calling this very small club. You might also look at differentiation that this factor, this relationship, created from competitors in the market. So if I'm a newsagent buying Kit Kats from Nestle, that doesn't really differentiate me from anybody else. But if I am one of, if not the, but one of a very few entities that can sell a market-leading test, that does differentiate me, because most other competitors, nearly all other competitors, are going to have to do something else to get to market, not have the benefit of this product. So that's a differentiation. And all of these are just examples of factors which might, and perhaps very often would, bring a particular counterparty's relationship within the scope of valuable commercial relationships of a firm, such that it was then possible to see that benefit would be derived by a partner from that relationship. And if the partner derives a private benefit, his or her own benefit, then that's precisely what must be accounted for to the firm. In putting those forward, I'm not trying to substitute a checklist, but rather simply to offer my thoughts, what they may be worth, on the general concept that underlies it. Now, I said yesterday that we hadn't seen a definition from the appellants, but I spoke too soon, because at that point, I'm afraid I hadn't read the note which was handed up yesterday morning, but yesterday evening I did manage to read it. The note needs a little bit of care, because it was said by Miss Hilliard, and I quote, to be a note of the references that we found to business connection, which is what my Lord Justice Newey asked for. And indeed there are such references, but if the reader has the patience to get through to page 6, you'll find at the bottom of that page something which goes beyond case references. But I'm not going to complain for present purposes about that, because it's actually helpful to see it now rather than to face it at some future occasion. So we now have, and it was given in on the morning of day 3 of the appeal in capital letters, the appellant's case. And I suppose we should all be grateful that we have it. In the circumstances, the appellants suggest that a partnership's business connection is a subspecies of its goodwill. It's not the entirety of its goodwill, because the partnership's name is also an aspect, for instance. Rather, the partnership's business connection is the partnership's relationships with customers and perhaps other parties, which are of such a character that they belong to the firm, quotes, can be considered a partnership asset, see John Taylor's, command some degree of loyalty and attraction, and have some saleable value. Now, quite a lot that one can say about that. So, relationships, we agree, and that is in effect the meaning of the word connection. And if you take out the word perhaps, we agree with customers and other parties. And of course, if Parliament had wanted to limit Section 29 to customer connection, it could very easily have said so. Even in 1890, customer connection was a phrase that one finds. Business connection is necessarily a wider concept than merely customer connection. But then the rest is slightly different. If one, I should just say, by the way, and I'll come back to this, one can see that, as is recognised here, John Taylor's is an example of a supplier, if you can call the district council that, higher up in the chain, being treated as a business connection, and the case is necessarily authority for that. It's East Lindsey District Council held the freehold of the market to which the auctioneering partnership was granted a license. So that's a bridge that's already been crossed, if I can put it in that way. Another case which one might think of as involving something a bit like a supplier could be considered the Don King case, because the boxers, although you might say in one sense that the boxer is a client of Don King Inc. or Frank Warren, but the boxer also makes their services or their sporting prowess and their available to the promoter.
Depends on your view of sporting agents, I suspect, and what position they occupy as to which end of the telescope you look at.
Indeed, all I'm saying, and I think in some of the restraint of trade cases, the courts have said it's not actually always a very necessary exercise to try and categorise precisely where a relationship fits. But I'm just giving it as an example of someone that the boxer is not quite the same as a customer, and there's an element of at least making available services to the or making available an asset, the boxer's prowess and willingness to fight, etc., to the promoter. So that it's not about finding categories, and the word perhaps in my learned friend's definition, if that's what it is, it doesn't belong there. But there, of course, the fundamental problem is that these are factors which could well be taken into account, but are they things which are necessarily part of the test or have to be considered? And obviously, I submit they're not, because if Parliament had wanted that to be part of the test, then it would have defined the term and given these as parameters.
Which points are you specifically?
Well, those which are on the last 2.5 lines beginning, which are of such a character, and then there are.
So the belong is deliberately an inverted commas, but wouldn't you agree that? I think you may have used the concept itself. It's got to be the partnerships business.
Yes, there's got to be some association with the partnership.
It's the last part.
Well,
you disagree with can be considered a partnership asset.
Let me be really precise, my lady. I'm not suggesting that these are not factors that could be regarded. What I'm disagreeing with, if that is the proposition, as I understand it to be, just trying to interpret this on its face, there are 4 factors which are mentioned in the phrase beginning which are of such a character, separated by semicolons, and those are put forward, as I understand it, as being requirements for a relationship to be a business connection. Now, that's not, the case wasn't argued like that in front of the judge, and it wasn't argued like that until this document appeared yesterday. So these are, as tests, these are new, but, and we would say.
Sorry, I think I will push back a little bit on the last comment. I mean, there were a number of exchanges with the Hilliard which were very much along the lines of those last few lines. This may be the first time you say they've been pulled together. There's no doubt that those were very much the points that were being made.
Well, what was said was it needs to be exclusive. And there was a general comment about there needing to be special features. That's what the judge records.
Well, if you, for example, had an exclusive distribution agreement, that would undoubtedly be an asset of the partnership, which was termed to be capable of being sold and might therefore.
That would be property, wouldn't it?
I mean, I hesitate before coming to my feet, but paragraph 279 effectively set out what our submission was in closing, which refers to, so must have some character of exclusivity or the special relationship, asset belonging to the partnership.
Yes. I mean, the formulations there's a general direction of travel, I quite accept. The precision that we now get, so far as we get it, wasn't put to the judge. I mean, it wasn't suggested, for example, that it had to be an asset of saleable value. So if that were to be, I mean, it doesn't matter in a sense, but I don't want to get too distracted. The fundamental point is that these are not specific things which need to be proved in order for a relationship to come within the concept of business connection. They are examples of factors that a court would be entitled to have regard to in reaching its decision. If the suggestion is that these are gateways that a court must turn its mind to, I do say that the test has not been put in that way until now. The judge wasn't presented with an argument that you must consider under each of these 4 specific headings whether or not something is, whether a relationship is a business connection. This is a new development, but behind that, the fundamental point is these aren't suitable to be treated as part of the definition of business connection, although they point the way to the kind of issues that non-exhaustively, they are examples of the kind of issues that be considered. I gave you a list earlier when I talked about magnitude, persistence of association, structural factors, differentiation from the rest of the market. So these are all things that one can see in a particular case may lead a court to conclude that there is the relationship is something that falls within the concept.
I wonder, in a sort of way, how great the difference between you is. You certainly quarrel with the idea that it has to be of saleable value, but you accept it has to be of value.
Oh, I said has to be valuable, a valuable commercial relationship. Yes. So, and my lord, I was going to say that the judge made findings which, in fact, I would suggest answer these suggested requirements in a positive way. So, just to look at them, does it quote unquote belong? Well, yes. If there's something which attaches, then that gives it belonging, and if there is a persistent relationship, that belongs. If there is an element of loyalty, well, if you're part of a select group, as the judge found, and if the supplier turns away people who approach it to buy from it and refers them back to you, then that is an element of loyalty or attraction. And equally, if the partner recognises that you have goodwill in your local brand, that also is an element of attraction. And as to saleable value, well, the judge did find, as I showed you this morning, that the goodwill had some value. So, and the goodwill, now that's what you could interpret that as the selling to the customers of the business, but since the exclusive source of that sale was the receipt of product, the ability to buy the product from Acon, it must follow that the Acon relationship also had some value, because the Acon relationship can be translated through the partnership's brand, the value of that brand, its trading history and so on, can be translated directly into something which the judge found had value.
I mean, maybe here the distinction between being valuable and having a saleable value is of significance. I mean, if at the point of dissolution you went to a prospective purchaser of the goodwill and said, we've got this arrangement with Acon, the purchaser might say, well, that's all very well, but that's really a relationship with one or more individuals. We're not going to get the benefit of that. The fact that we've taken over your name isn't going to persuade Acon that they should deal with it, us.
Well, the purchaser might consider that, but he would, I suggest, also consider the fact that Acon know that using this brand, there's already been a history of successful trading. So Acon has managed to sell its products into the UK successfully under the Hughes healthcare brand. So
But
to
the
suggest
main
that it-
source of sales is gone.
I'm sorry?
The main source of sales is gone because Newfoundland isn't buying them anymore. So now, from the point of view of the prospective purchaser, the relationship with Acon seemed to be built on a relationship with one or more individuals. And although Hughes Healthcare was selling a lot of product, that was actually selling to Newfoundland, which is no longer going to be buying them from.
Well, my lord, first of all, that is, with great respect, a question of degree. So the judge specifically found, paragraphs 236 to 238, perhaps we can just turn that up, that there were customers of the partnership, not Newfoundland customers, but customers of the partnership. It's page 130.
I'm not doubting the finding that there were customers, but most of the sales, as I think is apparent from the judgment, were to Newfoundland.
But we're considering the question, which is in itself not the statutory question, whether there was saleable value in the goodwill. And if your lordship is putting to me, well, the value might have been depreciated by the fact that Newfoundland was making the majority of sales to its smaller customers, I can perfectly well accept that as a possibility, but it doesn't answer that, doesn't negative the question that's posited, which is there saleable value? It doesn't have to be a particular value, just some saleable value, and the judge finds in terms, paragraph 238, page 131, Collinson's purchased a good number of LFTs from the partnership. That alone meant there was some goodwill in the partnership's business. Moreover, people in the UK were, at the time of dissolution, purchasing branded tests, and he defined that as Hughes branded, in significant numbers, as demonstrated by the fact that Newfoundland was making significant sales. So the partnership could have, the judge doesn't find that the partnership couldn't stop its arrangement with Newfoundland. The channel to the market has the Hughes brand on it in the UK. And so the judge concludes, he makes no finding as to the precise value of the Hughes Healthcare brand business name, but it clearly had some value at the time of dissolution. So if we're asking yourself, well, is there a business connection that has saleable value, then on the judge's findings, the answer is yes. And so I agree to this extent that actually, on the facts of this case, when you break it down, the appellant's case in paragraph 14 of this document is one that we satisfy. My point is that as a matter of law, those don't contain statutory requirements. It would have been easier if Mr. Justice Richards had gone through the exercise of saying, not I'm trying to supplant the definition, and he may have been chary of going through the exercise because he could have had that in his mind, but saying this is the sort of general concept that I'm talking about. And in the bundle that we had of additional cases which we handed up yesterday.
Just before you go to the cases,
Well, I'm just,
give me
yes.
the, no, I must have it somewhere else, but can you just give me the reference to those findings about goodwill that you were referring to?
Yes, a value. So it's pages 130 to 131, paragraphs 236, 237, and in particular 238. I didn't read out 237, but the judge records the case, advanced by Miss Hilliard, that at the time of dissolution there was no goodwill at all, and the goodwill of the partnership's business was valueless. And the judge specifically addressed that, rejected.
7238.
And that's 236 to 238, my lord, yes. And then the other reference to goodwill having value.
Sorry, yes, 238 refers to the fact that Newfoundland is
Well, but it's because Newfoundland is selling Hughes branded tests. But my lady, I do want to push back on that a little. Let's look at 238. Collinson's purchased a good number of LFTs from the partnership. That alone, the judge finds it isn't appealed.
No, I saw that.
Yeah, so there was some goodwill in the partnership's business. So even if we stopped there, I'm afraid my learned friend is still stuck with the fact that there is some value in the business, but he goes on to find that generally people in the UK were purchasing branded tests. That means Hughes Healthcare branded tests. It's a defined term in the judgment, in significant numbers. He says it's demonstrated by, though not exhausted by, the fact that Newfoundland was making significant sales. Newfoundland is able to buy, but if the partnership chooses, the partnership can stop Newfoundland buying. The judge doesn't find that Newfoundland had some arrangement which entitled it to a fixed period of supply.
Excuse me, no, that's not right. We couldn't stop Newfoundland going direct to ACON. We couldn't do that. There was never an agreement with Newfoundland that they would always buy through the partnership. That's why, effectively, the partnership had no option when Newfoundland wanted to go direct to ACON to just allow them to go to, because there was no way of holding them back.
Yes, well, we're always grateful to hear Ms. Hilliard's off-the-cuff thoughts, but these ones are wrong because Hughes Healthcare branded products could only be sold with the permission of the partnership. So if Newfoundland wanted to sell products, it might or might not have been able to go to ACON. In fact, Mr. Hughes successfully persuaded ACON, at least for a period, not to deal with Newfoundland. But one thing that Newfoundland could not have done, independent of the continuing agreement and consent of the partnership, was sell branded tests. And that's what the judge is talking about here. So Ms. Hilliard has missed the point. Now, what the judge finds, and it's not appealed, is that the Hughes Healthcare brand had some value at the time of dissolution. And that finding is in no way dispelled, with great respect to my Lady Justice Falk, by the fact that Newfoundland was making some percentage, not stated by the judge, of the sales at the time of dissolution.
As I understand it, you're saying that obviously you need to go one step further, but I understand you're saying the Hughes Healthcare brand had some value. That must mean that the relationship with ACON had value, as I understand it, because that's the supply.
Yes, that's right. So the goodwill has value.
Yes, it does, the one doesn't necessarily follow from the other.
But
Because a buyer of the Hughes Healthcare business might say, "Oh, yes, there is value in this brand," but they need to be able to rely on the continued supply. Otherwise, there's no business unless they can find another supplier who will.
But the judge's finding that it had some value presupposes that there would be some ability, not certainty, but some ability to attach some value to that prospect. And you can attack people all the time, as my lady knows much better than I do, attach value in transactions to the commercial prospects of a business which aren't guaranteed. I mean, it's just absolutely fundamental. And ultimately, most businesses depend on their fortunes from who's going to buy from them, from people who are not committed. And there are many businesses which have no long-term contracts at all. I mean, I'm reminded of a case that I did called Baird against Marks and Spencer's, where Marks and Spencer's had their big four suppliers who until the early noughties supplied nearly all their products, Courtaulds and the like, and famously they did not have contracts, and vast amounts of business was done. And I acted for one of those suppliers, and we failed to persuade the Court of Appeal that there was a, quote, relational contract when M&S conducted a big review and decided that they were going to move their manufacturing offshore and all these businesses that had, etc. But the idea that Courtaulds couldn't have had its business valued by the fact that it, for 40 years or longer, it had been selling to M&S simply because it didn't have a long-term contract that extended over multiple seasons would have been a nonsense. Now, of course, it could be said, oh, well, that's 40 years and so on, but every case depends on its facts. This was a pandemic which only started in January 2020 and which was, we all expected correctly, was at some point going to blow over. And in that context, everyone was moving very rapidly, et cetera, et cetera. So I do push back, I hope, and not disrespectfully to my lady, that the judge's findings have to be taken, and that even were the factors put forward in some sense necessary requirements, the factors put forward in this paragraph of the document, in some sense necessary requirements, and I submit they're obviously not. In fact, they are satisfied on the judge's findings. So we say that it's also worth looking just briefly at some of the authorities on.
Well, the other paragraph that I was expecting you to take us to was 427.
427, yes, I was, just because your lordship asked for the references, and the 427 says that the 47 little 2 sub A, the goodwill was not of negligible value.
And he says included but not limited to, but he certainly doesn't list anything, as far as I can read it, up the chain. I mean,
Well, that's in little 4, isn't it?
yeah, but that's not included within goodwill.
No, it's not included within goodwill, but it is the
Since
source of the ability to.
he lists it separately and just simply saying it's a business connection.
Yes.
So
However, all their tests, all their sales were of the ACON test, and the quality of that test was.
you got into this submission because you got into the submission by saying that goodwill was something of value, not negligible and saleable, because that's the test you were shooting at that Ms. Hilliard, you say, had set. All I'm doing is pointing out that if that is your frame of reference, I don't see it from, at the moment, section 4, paragraph 427.
Because the point I'm making is that.
I know you don't accept the test, but I'm just saying.
No, of course, my lord, I appreciate that. I'm doing it by a process of, as it were, extrapolation or induction, whichever it is, that the judge finds that goodwill had some value. The ability to sell depended entirely on continuing to have supply from ACON. So it is a necessary implication in what the judge found, that the ACON relationship also had some value, because unless you could get ACON to sell, your goodwill did have no value. So the judge's finding carries with it the imputation or connotation that the ACON relationship had some value. And one can see that, for example, when one looks at the ACON response to Mr. Hughes saying, I'm going to split up with Mr. Manduka, asking about the IP rights, that ACON are interested in the brand, and the brand has enabled them to make
I must say, I'm not so convinced by that point, because they seem to be worried, as my lady said, about infringement.
But if you're using, as the judge finds, there are significant people in the UK are willing to buy significant numbers of the Hughes healthcare brand. So I do suggest that, I mean, whatever interpretation one puts on the messages, put it this way, it would be natural for a manufacturer to have an interest in a brand which had demonstrated its ability to make significant sales with the manufacturer's products. And therefore, you would expect ACON to place some potential weight on that. Now, how much that would be, what the valuation will be, who can say? We don't have any expert evidence or anything like that. But what we do have is an obvious chain of commercial logic, and we have the judge's finding that I pointed to, and my submission, the conclusion does follow that even on this, even were it the test, which it isn't, on the facts and on the findings of the judge, we would meet this test. So I'm going to press on. There are some authorities, and I hope you have a bundle. I'm not sure what it looks like, but you don't.
No idea. Which one is it?
The authorities bundle, further authorities bundle.
So that's distinct.
You may have been having this yesterday. It's the one about goodwill.
Tesco and Hunt, Trago and Hunt.
Trago.
These are your additional authorities regarding goodwill and business connection.
Thank you very much.
Yes.
Trago So if we could go in Trago, so that was a case on a partnership, Varnish and Japan manufacturer, which was then where the goodwill of the business was sold. And the question is, what is the implication of that in terms of the future activities of the vendor? And in the leading speech of Lord Herschel, having reviewed the various authorities on the extent to which there was an implied restriction, was it customer solicitation, was it dealings, was it a non-compete altogether, and so on. At the bottom of page 16 of the law report, the last break on the page, he refers to a case for Lord Eldon, which is called Crutwell, who said, it's 2 lines into that bottom paragraph, the goodwill which has been the subject of sale is nothing more than the probability that the old customers will resort to the old place. And then Lord Herschel, says at the top of the next page, if the language of Lord Eldon is to be taken as a definition of goodwill of general application, I think it's far too narrow. Goodwill, I apprehend, said Vice-Chancellor Wood in the case called Churton, must mean every advantage, every positive advantage, if I may so express it, as contrasted with the negative advantage of the late partner not carrying on the business himself, that has been acquired by the old firm in carrying on its business. And that, we say, is quite a useful formulation. Every advantage that's been acquired by the old firm. And Vice-Chancellor Wood went on to say, whether connected with the premises in which the business was previously carried on, or with the name of the firm, or with any other matter carrying with it the benefit of the business. So 200 years ago, nearly, obviously focused on very different things. The physical location would be important, but any other matter that carries with it the benefit of the business can generate an advantage which would be embraced within the concept of goodwill. And then, and obviously it will all depend on the circumstances. At the bottom of the page, Lord Herschel says it's the connection thus formed together with the circumstances, whether of habit or otherwise, which tend to make it permanent. Just note that word, because I'm sure Miss Hilliard would like to say, oh, well, you can't have customer connection unless it's going to be permanent, but we say, not so, that you can have a business connection even if it's not a till death do us part. This is simply Lord Herschel talking on the facts of the case or giving a general indication. But habit or otherwise is the phrase that constitutes the goodwill of the business, and then it's this which constitutes the difference between a business just started, which has no goodwill attached, and one which has acquired a goodwill. Well, by the time of dissolution, this partnership had not just started, it had been trading for nearly a year. And whether it was 2 months, 4 months, 6 months, 8 months, doesn't matter. It had been trading, and as the judge said, paragraph 52, it had built up. But through successful trading, it had built up goodwill.
I mean, this is all in the context of a partner who was off trying to get the customers.
Yes, yes, it's talking about customers, and at the bottom of page 23, Lord Herschel makes the important general observation, 4 lines up in the bottom. What goodwill
Sorry, page 23.
23, my lord, last break on the page. Second sentence, what goodwill means must depend on the character and nature of the business to which it is attached. Generally speaking, it means much more than what Lord Eldon took it to mean, which was, and then he cites again the goodwill which has been the subject of sale is nothing more than the probability that the old customers will resort to the old place. Often it happens that the goodwill is the very sap and life of the business, without which the business would yield little or no fruit. It's the whole advantage, whatever it may be, of the reputation and the connection of the firm, which may have been built up by years of honest work, etc., or lavish expenditure of money, but whether it's days or months or years, again, question of fact and degree. So let's move on in the interests of time In the case, in this bundle,
Sorry, just before you leave, I see it said, this may be going off another red herring, but briefly, top of page 20,
yes, no.
Lord Herschel says must be treated as settled that vendor doesn't come under restriction not to carry on a competing business. On the other hand, we see from the head note, and I'm sure it's in the decision generally, that the vendor can be restrained from soliciting people who are customers. So suppose you've had a partnership, the goodwill is sold, one or more of the partners decides to carry on a competing business, that's all right. This might suggest that that person can't solicit existing customers of the old partnership, as I understand it. But would you suggest that the former partner could not go to an old supplier?
If there was, would I suggest that? If the old supplier was part of the advantageous arrangements, and there was, as opposed to just sort of open to all comers, then I would suggest that, and that would the logic of the principle of non-derogation from grant, which the House of Lords reluctantly accepted had to be stopped non-solicitation because of a long line of previous authority, but it would extend to other business counterparties than simply customers if they are part of the goodwill, which are the advantages of the business. Yes.
And would that depend on whether or not it could prejudice the purchaser of the goodwill? I mean, plainly, if someone's bought goodwill and the ex-partner then wants to sell to the old customers, that's to the prejudice of the purchaser. If, on the other hand, you have even a supplier who sells to a small club, and you persuade that supplier to sell to you as well as the purchaser, that's not to the prejudice of...
Well, it can be, if they're the market leader and the public are more likely to want to buy those products than other products, and they've got official validation, etc., then it would be prejudicial, absolutely. Yes. The next case...
Sorry, before you leave that, Lord MacNaughton sort of had something... I mean, Lord MacNaughton approached this, I think, along the basis of you can't derogate from grants. But it was interesting what he said. I mean, is there something interesting as to what he said at the bottom of page 24 and top of page 25? He says big long sort of stuff that partners can generally set up, push their wares as much as they please, etc., etc. But then the restrictions are he must not make his approaches from the vantage ground of his former position, moving under cover of a connection which is no longer his. You may not sell the custom and steal away the customers in that fashion. So, to that extent, what he seems to think is that the connection that's actually not capable of being used is the one that the partner cannot do, is to, as it were, pass himself off as still connected with the partnership.
No, I don't read it in that way, but the relationship is what's been sold by the sale of goodwill.
So
that's why
moving under cover of a connection which is no longer his. In other words, it wouldn't be possible for a partner to, as it were, pass himself off as still a member of the partnership he was previously a member of. But he can, apparently, as long as he sort of does it in his own right.
Well, no, that's not the position with respect. First of all, I interpret the word connection as just meaning the relationship. The relationship is no longer his because it's been sold. And it doesn't matter whether he pretends to be the old partnership or not. The point is that there was a relationship to which he had access, which he knew about because he was involved in it when he was part of the selling business. and that he's sold that relationship along with the business because there's been a sale of goodwill, not just merely a sale of premises or hardware, etc. And then the question is, where do you draw the matter of public policy? Where do you draw the line in terms of what the implied restriction is? How far do you go? And do you stop at non-solicitation or non-compete, which is a different sort of question from what we're dealing with. But I don't, with respect, interpret it so narrowly as that. I don't want to.
I know you're running
Well, I'm
short of
just
time.
conscious of the time.
I'll ask you lots of questions.
Perkins and Schoen, which we looked at briefly on day 2, is at tab 3 of this bundle. I'm sorry that the pages aren't numbered. So this is the case where a distributor of darts equipment came up with a particular type of specification and gave it the name pentathlon for dart flights, those little things I think that you put in the back of the dart. And the surprisingly to some, that's a valuable commodity. And the paragraph 30 of the judgment of Mr. Justice Park begins with some general observations about goodwill. Perhaps I can just ask the court to read 30 and 31 to itself.
Yes.
And in that case, so he recognises that there could be goodwill in relation to suppliers. I'm going to press on in the break case, which is Mrs. Justice Gloucester, as she was at the next tab in the bundle. That was an express restrictive covenant of post-termination restraint in the employment context in a business of wholesale food, high-end wholesale food distribution, and again, I'm afraid not numbered. About 10 pages in, you'll find towards the bottom of the page the subheading "The Law," paragraph 15. That's the law about covenants in restraint of trade, and the intersection with the issues we're looking at is on the next page at subparagraph 2. It is for the covenantee to identify a legitimate business interest that is capable of protection. I'm sure all the members of the court have had to deal with many interim applications based on these principles, and the employer has to show, or the covenantee, forgive me, has to show legitimate business interest. And then over the page, the legitimate interests 9, which justify the imposition of a covenant of restraint of trade, are, and then relevantly for purposes, number 1, trade connection. So again, a general phrase. That's, you can also have trade secrets, and you can have staff stability. And sub 10, trade connection is established where it can be shown that by virtue of its position with the employee will have recurrent contact with customers, or in this case suppliers, such that the employee is likely to acquire knowledge of and influence over the customers or suppliers. So that recognises there can be a legitimate business interest in the supplier, nothing to do with a permanent contract, but simply the association with the supplier, which gives an individual some element of special knowledge or influence about the supplier.
Yeah, but this is all in the context of what might legitimise an actual contractual provision.
Yes.
Preventing an employee from contacting a supplier.
Yes, it is.
If you don't have that express contractual restriction, then you're thrown back into the sort of analysis that we just saw in Trigo, aren't you?
Well, yes, but the point I'm making is that if you're looking at whether what can constitute business connection. This is a recognition in an analogous field that a relationship with a supplier can give rise to a legitimate interest. It's part of the advantage that a business can have. There's the next case in tab 5 of this clip is a recent case, relatively recent case of this court, Primus and Triumph, which is just a general authority on goodwill, but it's useful because it contains citation from. It discusses, as you can see at page 703 and onwards of the report, what is the ordinary legal meaning of goodwill. And you can see at 704 between B and C, and this is in the customer context. Definition from Halsbury's Laws: the goodwill of the business is the whole advantage of the reputation and connection formed with customers, together with the circumstances, whether of habit or otherwise, which tend to make that connection permanent, the value of attraction. So that's a sort of synthesis of the kind of statements we saw in Trigo. In that case, the issue was whether goodwill meant what an accountant would consider it to mean, which is the addition of value over and above the assets. I'm sure my Lady Justice Falk will be able to tell me more precisely what that should be, but the sort of intangible, as it were. And then if you look at the next page, 705, there's a handy citation of the key parts from the Muller case. So Lord Macnaghten, I think my lady referred to on day one, Macnaghten's famous definition or description, benefit and advantage of the good name, reputation and connection of a business. That's italicized, and then he goes on to say it has just above G, a variety of elements, different businesses in the same trade. One element may preponderate here and another there. And he says to try and break it down into constituent elements, as he puts it below letter H, it would be as useful for practical purposes as it would be to resolve the human body into the various substances of which it is composed. Rather sinister metaphor, perhaps. But anyway, the point he's making is that obviously you can't just approach it in this kind of salami slicing way. And Lord Lindley's comments are interesting, somewhat less often cited in the next paragraph. He says it has no meaning except in connection with some trade, business or calling, when that's goodwill regarded as property. In that connection, I understand the word to include whatever adds value to a business, by reason of situation, name and reputation, connection, introduction to old customers, and agreed absence from competition, or any of these things, and there may be others which do not occur to me. So it's a very open-ended concept. It's evolving all the time. Anything which adds value to a business.
Although paragraph 39, the conclusion, goodwill and sale of business refers to the type of proprietary right representing the reputation, good name and connections.
Yes, because and is different to the accountant's meaning. So the issue there was simply, does it have the general legal connotation, and they didn't need to go into the issue we're looking at, or does it have the accounting meaning of the surplus value, surplus intangible value? So that was why Lord Justice Coulson, before we leave that, and only because of the criticism that's been directed at Mr. Justice Richards, I note at the bottom of 704, paragraph 29, where Lord Justice Coulson was addressing the finding and the conclusion of Mrs. Justice O'Farrell in that case. He says, I accept that paragraph 496 of the judgment might in hindsight have benefited from an explanatory sentence or two. It's clear the judge was giving the word goodwill its ordinary legal meaning. And in the footnote, he says it's not a criticism. He refers to the length of the trial, the raft of issues, and in this sentence, a certain amount of explanation fatigue can be forgiven by the time the judge reads paragraph 496. That's a phenomenon that members of the court probably more experienced than they would like. And Mr. Justice Richards didn't, in similar vein, one might say, well, it might have been better if he'd had an explanation. But what he did do was to say, these are the factors which I find in relation to this partnership, the Acon's selectivity, turning other customers away, etc. And that's why I find it was a business connection, along with obviously the value of it to the
Except I think you put it more mean, you say it would have been in fact wrong of him to attempt to define it. I thought you said just there a moment ago it would have been, perhaps it might have been better if he'd given an explanation or definition. I thought your main submission was actually these are words of ordinary English words, and it's simply a matter of fact. What in the old world used to be called a jury question.
Well, yes.
And you're going to suggest at some point, I suspect, we shouldn't interfere with the judge's evaluation of the evidence in that respect.
I do, of course, suggest that. Thank you, my lord.
I was only just suggesting, just to make your submissions sort of shorter, but that's
no,
I suspect you're going to be saying, because you
yes.
think you say. In fact, it would have been wrong in principle for him to attempt to gloss, define, or otherwise the words business connection. He was right to do what he did.
It can sometimes be helpful without us attempting to supplant a statutory definition by another definition, which courts are sometimes, judges sometimes criticised for by the House of Lords and Supreme Court. It can sometimes be helpful to say this is the general idea that I'm aiming at, so that the reader, for example, this court, has a sense of that. But if in fact what a judge does is to apply the words to identify on the facts, the particular factors that have led him to his conclusion, and those are factors which he was entitled to point to, then that's sufficient. I was simply pointing out that that there is a sense in which including an explanation is a sort of maybe desirable but not a necessity for a judge to include in his written reasons. In this case, therefore, I've told you about all of the features many times, and I don't think anything will be gained in my repeating it. I do say that this is a case where, to recite some very well known, picking up immediately on what my Lord Justice Snowden was anticipating.
You're going to cite either Volpe or Sprint Room or one
Yes,
of those cases,
exactly.
and I don't think you need
I'm
to
sure
spend
you
time.
don't need to. We've got it. I imagine the
Yes.
Lord Justice Lewison's comments in
Yes.
Shabani would see it on all amendments.
Yes.
So,
And as I can see that we're not giving you that much time.
no, that's fine. I understand, my lord. So that then is business connection or commercial relationships of value, and that's why we say that the conclusion was one that the judge was entitled to reach. Indeed, we say he was plainly correct, but that's not the test. So can I just come back then to the fiduciary duty issue? I just want to take your lordships to Rukadze, or recovery partners, in the Supreme Court. That decision came out in the Supreme Court more or less contemporaneously with the judgment. See, to be considered by Mr. Justice Richards. We've got it in our authority bundles at tab 64. And the relevance of this is that we say it puts paid to the idea that that a fiduciary, in order to be liable after the termination of the underlying active relationship, has to have committed a breach prior to that termination, and one can see that in the headnote, looking at the between F and G, first of all, that a fiduciary was under a fiduciary duty to account to his principal for any profits which he made from, out of, or which were otherwise sufficiently connected with that fiduciary relationship, unless the principal had given fully informed consent. Such duty existed in its own right, being imposed by equity on all fiduciaries, inherent aspect of their undertaking of single-minded loyalty rather than being merely a discretionary remedy. The duty didn't depend on a demand for an account by the fiduciary's principal or upon an order of the court, but rather arose at the moment when the profit was received. Determining whether profits were profits from, out of, or otherwise sufficiently connected with a fiduciary relationship did involve what might loosely be labelled causation analysis, in that it had to be asked whether the profit owed its existence to a significant extent to the application by the fiduciary of property, information, or some other advantage which he enjoyed as a result of his fiduciary position, or from some activity undertaken while he remained a fiduciary which conflicted with his duty to the principal. And then that the court did not concern itself with the counterfactual but for principle. So that summarises the conclusion was unanimous. There were different judgments. The majority judgment given by Lord Riggs on behalf of himself, Lord Reid, Lord Hodge and Lord Richard, so 4 of the 7 members of the panel. As the headnote recalls, the ultimate point at issue was an invitation from the defaulting fiduciaries to, in effect, make inroads into Keach and Sanford and apply a common law counterfactual test, what would have happened but for our breach of duty as a precondition to recovering money, which was rejected by the court. It basically said the old rules and the policy should be maintained. But in the course of doing that, it was necessary for Lord Briggs to analyse the underlying fiduciary concepts. So he says at paragraph 2 on page 1774 of the bundle, let us see that the equitable principle and issue of this appeal, put at the highest level of generality, is that the undertaking characteristic of a fiduciary relationship to act with single-minded loyalty, etc., means that the fiduciary must account to the principal for any profits which the fiduciary makes from that fiduciary relationship, subject to fully informed consent. And then at paragraph 4, so paragraph 3, he refers to not only trustees, but the rule being equally applicable as between fiduciaries such as company directors and their companies. Says there's no difference in principle about the underlying profit rule. 4, where profits are only made by the fiduciary after the fiduciary relationship has ended, which he calls post-termination profits, the fiduciary will still owe a duty to account if the profits have been derived from or made out of that former relationship. So again, one sees that word derived. Typically, the profits may be attributable to the development of an opportunity which the fiduciary learned about while performing his fiduciary role, facilitated by the use of information which he received while acting in the same capacity. Thus, the duty to account for profits can outlast the termination of the fiduciary relationship, for example, by the resignation of the director of a company. Disputes often arise as to whether post-termination profits fall within the duty to account, i.e. whether they've arisen out of that relationship, and, as will appear, the courts have used various formulae by which to describe the link between the fiduciary relationship and the relevant profits necessary to give rise to the duty to account for them. The outcome of such disputes is often very fact-sensitive. And then, so that's all important, and we say illustrates the general principle. And then he refers in paragraph 5 to the issue about the but-for counterfactual, and that was being challenged in the appeal. At letter H at the bottom of the page, he said there's a sharp difference between the parties as to whether some form of what may loosely be labelled causation analysis already forms part of the court's tasks in determining whether particular post-termination profits fall within the duty to account. Over at page 1777, equitable principles, paragraph 15, he cites Lord Upjohn in Boardman and Phipps, saying that rules of equity can be stated only in the most general terms and then applied with particular attention to the exact circumstances of each case. He says it's not surprising that the equitable rules or principles with which its appeal is concerned have been restated in different factual contexts using different language, no doubt particularly appropriate for the specific facts to which the principle was being applied. Although it would be necessary to cite some of the most well-known examples of the way in which the fiduciary's duty to account for unauthorised profits has been described, the task is not to arrive at some precise formulation as a sort of lowest common factor, but rather to elucidate the underlying concept which they seek to encapsulate. And so you've got to look at what's the purpose, and then he refers to the central purpose of the rule that a fiduciary mustn't keep himself a profit from his position as such. He says it's over the page, it's to protect or deter those who've undertaken obligation of single-minded loyalty to someone else and been tempted by human frailty to fall short of that obligation, and then he cites, of course, Keach against Sandford. Then over the page, paragraph 20, he says, having cited more references to the prophylactic basis of these rules, he says in paragraph 20, it's important, particular importance to note the fiduciary duty to account for profits is a rule governing the conduct of fiduciaries which exists in its own right. It's a duty or obligation imposed by on all fiduciaries as an inherent aspect of their undertaking of single-minded loyalty to their principles. It's not just a discretionary equitable remedy for the breach of some other duty, such as the conflict rule, nor is it necessarily triggered by some other breach, although it very often is. A fiduciary may come to generate a profit out of his role as such without committing any breach of trust. It may be an authorised use of the trust property or of his fiduciary powers, but he must then account for that profit if it has been made from or out of his fiduciary position, not keep it for himself. The wrong which may lead, so one can see here it may or may not be the case that Mr. Hughes, trading after dissolution on his own account, is doing something wrong. The wrong is not accounting for the profit. And that might be one difference between the pre-dissolution and the post-dissolution situation. Lord Briggs goes on, the wrong which may lead to a court order for an account of profits is in such a case no more or less than the failure to account itself by a fiduciary who wishes to keep the profit for himself. The duty to account doesn't depend on a demand for an account or upon an order of the court. There is simply not a relationship between breach and damages for loss, which has to be filled by rules which are routinely applied by the common law. And he then goes on to say it's not to be confused with the remedy of an account of profits, where he says, if it's, for example, IP truly is just a remedy, doesn't depend on the defendant being a fiduciary. And then various cases are cited, well known. Bottom of the next page, paragraph 25. Important though it is to understand that a fiduciary's obligation to account for profits other than those which he's been authorised to retain for his personal benefit is a duty arising on the receipt of profits, rather than just a remedy for breach of fiduciary duty, but it doesn't of itself answer the sometimes difficult question whether a particular profit made before or after termination of fiduciary relationship falls within the duty to account. Undertaking the role of a fiduciary does not in itself prohibit the fiduciary from carrying on other profitable activities which have nothing to do with the subject matter of the fiduciary relationship. The director of a company making cars may perfectly legitimately carry on an activity of betting on horse races out of working hours, keep any profits he makes himself. The opposite would be true of an executive director of a company operating a horse racing stable if his betting was informed by what he learned while at work, unless the company gives consent. Similarly, subject, of course, to any contractual restraint, the director of a company may, after resignation, set up and make profit from carrying on a similar business to that of the company, provided he doesn't use information or pursue opportunities that came to him from his fiduciary position in the company. The duty, which may well extend beyond the end of the fiduciary relationship, is to account for profits made from, out of, or otherwise sufficiently connected with the fiduciary relationship. Judges have over many years used a variety of different phrases to encapsulate that requirement for a link between the relationship and the profit. Sometimes they've done so when the existence of the link is not in dispute. Sometimes used a phrase tailored to the facts of the case under review, phrases used at different levels of generality. And then he goes through the cases, Regal against Gulliver, Boardman and Phipps at paragraph 27, where Lord Hodgson said, proposition of law involved in this case is that no person standing in a fiduciary position when a demand is made upon him by a person to whom he stands in the fiduciary relationship to account for profits acquired by him by reason of his fiduciary position and by reason of the opportunity and the knowledge, or either resulting from it, is entitled to defeat the claim upon any ground save knowledge and assent of the principal. Over the page, 29, Lord Justice Lewis, in a case called Keystone, says he doesn't accept the argument that the breach of fiduciary duty must be a cause of the profit, although as we'll see that's glossed or gone over again by Lord Briggs. There must be a sufficient degree of connection between the breach of fiduciary.
Do these parts, are these parts of much relevance? I follow why earlier parts are relevant. Is this part really
Well,
needs help.
let me go straight to 20 to 34 on page 1784, where the causation aspect is summed up by Lord Briggs. He says, I can't easily halfway through. He says, the extent to which a causal test of some kind is already built into the law about the identification of profits falling within the duty to account is the main issue about the current law, which calls for close analysis. In the end, it depends on what is meant by causation and causative test. It's used as a label for the well-known causation test, which the common law applies. Tort or contract clearly has no place in this equitable context. If it's used in a wider sense, so as to refer to and then exclude any causative analysis, the question whether a person's made a profit out of his fiduciary position, then I would say goes too far. Causation in the protean sense of asking whether event A played a causative part in the occurrence of event B is inherent in phrases such as by reason of, out of, by virtue of, owing to, or resulting from, used in the well-known cases as summarised above, and I would say derives from is also an analogous phrase, but the analysis, he says, differs from common law causation, and then paragraph 36, he sums it up. He says, just below, halfway through the paragraph, the question is not would the profit have been made, even if there had been no antecedent breach of fiduciary duty, but did the profit owe its existence to a significant extent to the application by the fiduciary of property, information, or some other advantage which he enjoyed as a result of his fiduciary position?
Can I just understand the potential relevance of that? Would that be, would you say that that's the sort of approach the judge should apply in trial too?
Yes, broadly, yes. I mean, that section 29 can be
No,
regarded.
that's a threshold. It's not, the way that I think the judge has set up trial two is you look at what are all the contributing factors to the profit in the Danish deal and you carve it up. This is a different approach.
Well,
So I'm just trying to understand.
I'm not sure, with respect, that it is a different, the underlying essentials.
Well, the reason I say that is because the result in recovery markets is basically the whole of the profit had to be accounted for, subject to an equitable allowance. So if you get translating that to what Lord Briggs says, 100% of the profits, because it presumably met the test of significant extent, subject only to the discretionary equitable allowance. I don't think that's the way that, I know maybe not for today, but I'm just trying to understand where this fits in.
Well, there will be, one can imagine the possibility of two issues at trial two. One will be whether it should be an account, a duty to account for the whole profit or a duty to account for part of it on the basis that the benefit that has been derived by use of the partnership property name or business connection is to be taken as being the whole of the profit or part of the profit. So that concept of what's derived what is being derived would have to be applied. We will look briefly after the break at a case which my Lord Justice Newey may like, because it's about a news agent, where one sees that there is hypothetically difference between that sort of account and a more focused account. Another issue that one can foresee may come up is whether the account that is to be taken under section 29 can include an allowance of the kind that one had in the recovery case, or whether you, so it may be said by Mr. Hughes, you've got to give a discount, as it were, although that's not totally apt phrase, just my phrase, because the benefit was partly derived from factors which weren't the use of the partnership's property name or business connections, and I'm only under a duty to account for part of it. Or he may say, I'm under a duty to account, but I'm entitled to an allowance, and that's not inconsistent with section 29. So those are trial two potential issues that may be raised. I can see that. But the general notion of section 29, I submit, coheres well with what one sees in, for example, paragraph 36 of Lord Briggs's judgment.
Now, as you were saying a moment ago, we're coming to 1 o'clock. we've obviously delayed you a lot in all sorts of ways, but we need to reach a conclusion this afternoon.
Yes.
So how are you placed?
Well, the issue is whether you, how much time you're prepared to allot to, if any, to Miss Hilliard. She and I had agreed before we started that we'd divide the time, unsurprisingly, 50-50, so in a sense she's already had her time. But I will try and finish to leave her half an hour or so if the court would find that convenient.
Meaning by 3:45?
Yes.
Yes.
Without intending any discourtesy, obviously the length of time also is reflective of the amount of dialogue that takes place.
I think we will proceed on the basis that you have finished by 3:45. If this afternoon you see that our questions to you are causing you to get into difficulties, you better point that out, because you
Yes.
do need to finish by 3:45.
Well, I understand, my lord. And at the moment, of course, we're an optimistic profession, but I'm optimistic.
2 o'clock.
All round the table.